Well, welcome to the University of Chicago Law School. My name is Seth Orenberg, and I'm the president and founder of Law Inc. Law Inc. is a law and business society dedicated to bringing the law and business schools closer together. I got the idea for this event when I was actually watching Rick Carr interview Tim Wu about net neutrality, and I thought, this guy really is a really pro-regulation guy, and Chicago's got a lot of people here who are much less into regulation, you might say, and I'd love to have Rick have a conversation with Randy Picker and look at some other ways to look at these very, very important net neutrality, search neutrality issues. As the president of a law and business society, I also want to tie this into the greater practice of law and business and make it relevant to business students. So I added Nilay Patel to the panel because he's in touch with what consumers want, what businesses actually do, and Rick Rule is my future boss, and I think the best antitrust lawyer out there today who handles the Microsoft case. So by putting those three pieces together on the panel, I hope to give the students an experience of what's the academic version, what's the practical version, what's the consumer version of the hottest issues in technology.
Well, for me, a lot of the interest came from the fact that we're all iPhone owners, we all have Facebook accounts, and kind of being able to think about the legal issues that are coming out in those worlds that we interact with on a daily basis as a consumer, and having the perspective of an antitrust lawyer who represented Microsoft in the original litigation, and a bloggist who is at the top of his field in terms of reporting on Google and reporting on Facebook and Apple and those sorts of things, and just hearing how the law has evolved in this area is really cool as a new law student to get that big exposure right away.
The thing that sticks in my mind most is the copyright issues, because I'm kind of an IP person. So when we talked about, I guess, the way that Sony handled the recent hacking and how they went in and perfectly within their legal right, they sued the hacker and got an injunction against his spreading the code on the internet. And although it does nothing, they've damaged their reputation enormously in doing that, and doing something that's completely within their legal right. And it's interesting to discuss how the way that you handle legal issues like violations of the law is changing in the modern world because of technology, whereas enforcing your legal rights isn't always in your best interest.
So when you have like this Sony case, this kid hacked the PS3, right? And Sony sued him, right? Terrible PR move for Sony, well within their rights. Sony has now been attacked. Right, the entire PlayStation network has been taken down. They're stealing credit card numbers, or they think they're stealing credit card numbers. That's basically an act of terrorism. Right? But the back end of it is that when Sony did sue this kid, George Hotz, they did what you would do. I mean, any lawyer in this room, they sued him. They subpoenaed YouTube to see all the people who looked at his video. They subpoenaed his credit card processor to see who had bought his code. All the things that you would do, and people freaked out. Oh my God, Sony is way off the line, right? They're over the rails. They're doing things nobody would ever do. And it's like, well, yeah, I mean, if you were selling physical stolen merchandise, this is exactly what you do.
Well, but
it's just because it's this intangible online thing that people believe that regulation
and
is.
what I take it Rick does every day is you have to tell your clients, obviously, look, what your rights are on paper and your ability to enforce those, that's not necessarily in your best interest. That's what Sony's seen, and we've seen that repeatedly in these cases. And so you have to make a decision, a business decision, about whether it's really sensible to enforce your rights or not.
The discussion of AT&T and T-Mobile, because it's sort of a very big deal in terms of M&A, and also a very big deal in FCC stuff and antitrust stuff. There's a lot of issues going on, and they could have probably talked about that individual deal for about 3 hours.
There's Verizon, has 90-some million subscribers. AT&T is around there, and then Sprint and T-Mobile are the other ones. They're going to buy T-Mobile, and they're going to be way bigger than Verizon, 120, and then Sprint will be at 30 million. So now we have a duopoly. And AT&T's argument is, well, T-Mobile sucks, and they're not competitive with us now, so it doesn't matter if we buy them, because Cincinnati Bell is more competitive in southwestern Ohio than T-Mobile.
There is kind of a view today that maybe duopolies aren't that bad, and maybe two is enough. So it'll be interesting to see in the AT&T T-Mobile deal that they might come away with the argument that, gee, it's better to have a stronger, better perceived by consumers network on AT&T's part, fighting with Verizon.
I really liked the fact that they had 3 practitioners at the top of their respective fields, the academic technology blogger and the attorney. I particularly was interested in their discussion of the implications of device interoperability on antitrust actions.
The only manufacturer that really thinks about the consumer and builds a consumer relationship is Apple. And if you go and talk to Samsung or whoever, they say our customer is the carrier. So now they only have 2 major customers, right? And they're not competing as, I think, as ferociously as you'd like to see. And I'd like to see all of those manufacturers and all of those platforms begin to interact directly with the consumer and have the consumer say, well, I hate AT&T. My AT&T service is bad. I want to go take my phone, my device that I bought from a manufacturer, and plug it into a different service. And you cannot do that right now. You cannot,
but how does allowing this merger to go forward allow you to do that?
Well, so I mean, and I will openly say this is a naive and idealistic argument, is that this is a window for regulatory reform. And maybe that's wrong.
You really think the FCC is going to do something?
But you just mean that opportunistically, right?
Oh, yeah, right.
Yeah.
Well,
I don't mean it is real.
You actually have it, and I mean, again, it's an interesting sort of study more in politics than economics, but this deal is arising at a time at the agencies where they're much more willing to look at what you'd call behavioral remedies, which is another word for regulation, as opposed to
you just don't want to say it.
As opposed, well, the antitrust lawyers would never say they regulate, as opposed to structural remedies. Because for years, in fact, the old AT&T decree was all premised on the fact that you have to have structural remedies.
I think if you look at, we must have spent 40% of the time in that conversation talking about Google, because here you have a company that really represents, a broad swath of sort of the service layers of the internet, has their fingers in, multiple different areas because it's sort of where the business has taken them and kind of this core mission of search, and really challenging the present realities of the law, whether it's the Google Book search, we talked about that a lot, or in areas like they're getting into travel and creating a lot of interesting antitrust issues because they're buying up a company that services travel information kind of across the industry. And to really hear people pick that apart, I think, is a terrific opportunity.
I'd love to take Google Books, which I think I've written 3 papers on, a little cottage industry. So we don't know where we are, right? In the sense that if you've been following the case, the decision sat there for basically a year. Judge Chin ruled in February, finally, and found that the settlement was simply too much, too far. The critical issue in Google Books is with regard to so-called orphan works. Those are the works where we can't identify who the rights holder is. If you're an academic like me, those are the books you want to see online, right? I'm not interested in bestsellers. I'm interested in the obscure. That's why I'm an academic.
But again, I think that Google essentially, one could say, had a view that was not terribly respectful of the rights holders, was willing to, in a wholesale fashion, copy things without necessarily taking care of the rights holders if it got sued.
Yeah.
And it was, part of the argument Amazon, speaking of Amazon, was making was, hey, look, we copied stuff too, but we actually went out and negotiated the rights, which is inherently more expensive and puts us at a significant disadvantage.